Well, good afternoon, everybody. I almost said good morning. It feels rather unusual to be holding a webinar in the afternoon. I'm not sure why, but mornings always seem slightly more appropriate. But anyway, welcome. Thanks very much for joining us. I'm just going to share my slides and hopefully not reveal the car crash that is my inbox. There we go. We're all up and running. So yes, as I say, welcome. Thanks very much for joining us for this session on immigration and in particular recent developments and how they're impacting our schools. So we're going to look, I think, initially and probably most importantly at some of the coronavirus issues arising within the immigration system and in particular the concessions that the governments have put in place to address some of the issues that have been caused for people who are having trouble moving, making visa applications, those sorts of things. So we'll talk a little bit about how that's affecting us and some of the measures that are in place. It won't have escaped anybody's attention that there have been some fairly significant changes to the immigration system in recent months, principally to prepare the UK for the end of the Brexit transition period on the 31st of December, but some others, I would say, much needed changes and tweaks to the immigration system. So we'll look first of all at immigration as it affects students, the international pupils who come to the UK to attend our schools, and then we'll look also at some of the changes to the worker routes within the immigration system, and then finally I'm going to look at the position for European nationals and in particular how things have changed for them since the end of that Brexit transition period. But first of all, before I do too much work, I'm going to ask you to do a little bit of work if that's okay. Just got a poll for you all to complete, really just for my interests as much as anything else, to sort of see what parts of the immigration system you have personally. So it should be a poll popping up on the screen in a moment if it's not there already. So just like to, there it is, I can see it now. So yes, just like to know what your interest is in today's webinar. So you're in the HR function, so you're interested in employment immigration issues only. You're involved in maybe marketing, admissions, so you're interested in student immigration issues. Maybe you've got a more strategic role, so you need to know everything, need to have a good idea of what's going on. Maybe you've heard the rumours about how wonderfully entertaining my webinars are and you're just here for the entertainment, or now you are realising that you are in the wrong place and you're not interested in anything. So yes, if you could answer that for me. That's great, really good to know. So yeah, perhaps not unsurprising that most of you are here for the student immigration issues, and some people here for the entertainment. Well, that's very, very nice of you to say so. Thank you, and I'm glad to hear that nobody's in the wrong room, so to speak. All right. So moving on, and as I've already trailed, looking at the COVID concessions, we're still, to a certain extent, relying and taking some comfort from this statement that was made by Kevin Foster, the Minister for Future Borders and Immigration, gosh, almost a year ago, when we were really in the very early stages of lockdown and wondering really how much our world would change and significantly how long for. And there were lots of concerns about people who were stuck either in the UK and couldn't leave, people who were stuck overseas and couldn't return, people whose visas were due to expire, but with no clear way for them to extend their stay or otherwise not be penalised. And so the minister sort of stated, and as I say, we're still relying this as a sort of an overarching policy statement to a fair degree, that nobody will have a negative outcome through the immigration system because they were complying with the relevant guidance in relation to either staying indoors or shielding or not travelling or what have you. So that was the sort of the overarching position. And then since then, we've had a number of policy statements which set out specifics in relation to particular groups of migrants within the UK. And most of these on this slide really are focusing on student immigration issues, but some of them are applicable to employees or workers, sponsored workers as well. From a student perspective, one of the sort of concerns, of course, was that, and continues to be, that students in most cases aren't actually attending school. They are distance learning, either from within the UK or maybe they've returned home and a distance learning from overseas. And in normal times, were there no pandemic, then that would be a cause for withdrawing sponsorship or having to make some other arrangements in order for that student to be able to remain with the school. Distance learning or a blend of distance and in-person learning is permitted, and it's been the case for some months now that we've known that will be permitted up until the end of this school year. So distance learning is absolutely fine. There is still a requirement to monitor what the Home Office are referring to as engagement. So if it is clear that a pupil who is distance learning isn't logging on, isn't submitting work when they're supposed to be, if you don't have any engagement from them for a period of more than 30 days, then you are required to withdraw sponsorship. So that's just something to bear in mind. And if teachers and others who are engaging with those pupils aren't aware of that, where they've got international students who they're teaching, you should really make sure that they're aware of that, so that they can flag up whether there's been a failure to engage for an extended period. Absences due to COVID wouldn't need to be reported. So if a student is unwell and unable to attend classes, and maybe they've got a sort of extended bout of the disease, then that wouldn't need to be reported, and sponsorship wouldn't need to be withdrawn in those circumstances. So those are probably sort of the two main points, certainly as far as students are concerned, to get across. The guidance for student sponsors on COVID does say that if you are applying one of these or any of the other temporary concessions, then a note should be made of that on the student's file, so that if in the future you're asked, why you were allowing this cohort of students to study remotely, you can point to the fact that it was as a result and you were following the COVID guidance. I suspect that everyone will remember for quite some number of years the effect of this, but nevertheless it would be useful to have that note on file in case you are put on the spot and left scratching your brain as to why an absence wasn't reported when ordinarily it might needed to have been. The guidance also includes a reminder, and really this is aimed at schools, that your safeguarding duties do need to continue to be satisfied where students are still in the UK. And the issue here, of course, is that particularly for those students who would ordinarily be boarding at the school, they may be spending extended periods with an educational guardian, with a homestay family, maybe a family friend, and there are a number of issues there, of course. One being, and I'm sure almost, if not all, of you will be sort of well on top of the safeguarding duties that you will continue to have, and if there are any red flags as far as their particular living arrangements are concerned, then you would be taking the appropriate action as far as that's concerned. But the other issue to flag, particularly in relation to the pandemic, and particularly at this point, is that where a student under the age of 16 is staying with adults who are not close relatives as defined, then they would be, then if that's for longer than 28 days, or the intention is that that will last for longer than 28 days, then then the private fostering regulations will kick in. And we're not aware of any concession that's been announced in relation to that. So if students went home for the Christmas holidays, couldn't travel, so they've stayed with their stayed with their educational guardian, stayed with family friends perhaps, and they haven't been back to school because the boarding houses are still closed, then that will have been longer than 28 days, and so it would need to be reported to the local authority, and the relevant consents would be required from the child's parents. So that's certainly something that you should be thinking about. A number of schools have been engaging with us about that to make sure that those duties are complied with. Just a reminder in relation to the private fostering regulations that they only apply in relation to children under the age of 16 or under the age of 18 if the child's disabled, but ordinarily they'll only apply to children under the age of 16. So 16, 17 year olds and older, the private fostering regulations wouldn't kick in because a child is permitted to live independently, albeit they are living with somebody else. So under that provision, it's not technically a private fostering arrangement, but you would still need to make sure you've got the relevant approvals so that you can demonstrate to UKVI, if asked, that the parents were consenting to those particular arrangements. Another issue particularly caused by the pandemic is that in relation to students who are stuck overseas and haven't been able to travel to the UK, you'll be aware that sort of up until around the middle of last year, ordinarily the initial visa that child would be issued in order to travel to the UK was only valid for 30 days. And up until the end of last calendar year, the Home Office were issuing free of charge replacement visas, initial vignettes, which were valid for 90 days and were actually being issued free of charge. That concession, that little bonus from the Home Office has now ended, and now if a child was due to travel to the UK and the visa they've been issued has expired, that initial 30 or 90-day visa has expired, they have to apply again. They don't need a new CAS, they don't need a new confirmation of acceptance for studies from the school. They are applying for a replacement visa, a replacement vignette. So that would attract a fee, £154, as it says on the slide, and it's a new application process, so it does require them to attend the visa application centre in whichever country they're applying. So a bit of hoop jumping and a bit of a hassle for them. So if there is any prospect of children being able to travel into the UK within that validity period of their child student vignette, that should be encouraged, although it seems travel arrangements are about to get tougher, not easier, if anything, with the introduction of mandatory hotel quarantines, those sorts of things. So that doesn't stop people from those countries travelling in. It just means that they might have to undergo a quarantine period on their arrival. So yeah, do watch out for that. And I'm sure many of you have had queries from the families you're working with about the visa expiry days. All right, that's sort of broadly all I want to say about the pandemic for now, but we should have time for questions at the end. So do feel free to pop those in the chat box or get in touch with me afterwards if you've got any specific questions. Um, Moving on to what's changed as far as the immigration system is concerned. Well, for over a year now, I can sort of think back to the government talking about their plans for the immigration system and rehashing the old phrase that we're going to have a new points-based immigration system. Sometimes if a government minister is feeling particularly bold, he'll lean into his interview and he'll say it's Australian style. This points-based system that we're introducing. This is hackneyed old phrasing that's been around for well, the days of the Tony Blair government. So this certainly isn't new as far as immigration lawyers are concerned to hear this sort of phrasing. But we now have the Johnson government's points-based immigration system. And how does it differ from what we had previously? Well, the honest truth is that not very much. We've got a bit of changing in terminology. Some new categories are being introduced. Some are getting a bit of an overhaul, much needed overhaul, I would say. But otherwise, much is very say similar to how it was previously. So we've actually had a lot of these changes are now already in effect, and many of you will probably be aware of those. 5th of October, the Tier 4 categories were replaced by the student and child student routes. So two brand new categories, which, as we'll see in a moment, replace the previous categories for Tier 4 students and Tier 4 child students. 1st of December was when we got a very significant set of changes, certainly in terms of the volume, because many of the old immigration rules were completely deleted and rewritten. But despite the volume of new text that we received, actually what we had was really just a sort of a rejigging, a reorganizing of the rules themselves. The old employer-sponsored Tier 2 general category was removed and replaced by skilled worker, and we'll come on to how that differs, what the differences are there shortly. The old Tier 2 intra-company transfer category was replaced by an intra-company transfer category, and really not much more has changed in that category than that simple dropping of the words tier 2. And then, as I've said already, most other categories got some form of makeover, but not much more significant than that. Of a great deal of significance for a large number of people was the fact that from the 1st of January, European Union, European Economic Area and Swiss nationals, terms which I'll probably end up using interchangeably, so do forgive me on that, but for immigration purposes they all broadly mean the same thing. Those nationals who up until 31st of December continued to benefit from EU free movement rules are now in a position where unless they are entitled to apply under the EU settlement scheme, require immigration permission in the UK. And we'll come on to that towards the end, just precisely what that looks like. A new visa category was introduced on the 31st of January, the Hong Kong British National Overseas Visa, a fairly significant change. And I dare say that a number of you will have seen or had inquiries at the very least from Hong Kong families who are considering or have already applied under that category. And so their children will be considering coming to schools on that basis. So that's now in force, that's now up and running. We, on the 1st of July, will have a new set of right to work guidance. So for those of you working in HR who carry out right to work checks on new and existing employees, take note that from 1st of July, that will change. And that is because the deadline for EU nationals who are already in the UK or were in the UK before the 1st of January, the deadline for them to apply under the EU settlement scheme, which again, as we'll discuss a bit later, which grants them immigration status, allowing them to remain in the UK permanently if they so wish. That deadline is the 30th of June. So from 1st of July onwards, once that deadline has passed, there will be a new set of document checks which we need to carry out to ensure that everybody's got the right to work in the UK. One other change probably worth flagging that's likely to be introduced, well, no, sorry, that is going to be introduced in the summer is the graduate route, not sort of directly significant for in independent schools, other than perhaps marketing. Marketing people might want to talk to families overseas, and particularly if you're a senior school, you can let them know that there's now this post-study work category. So once they've finished studying with you, moved on to university, they then can get another 2 years in the UK after that relatively easily, and that will allow them to work and find a job. So if that's perhaps of interest in that respect, and also it might well be that many of you are recruiting graduate teachers, and some of those may be from overseas, in which case they may well hold the graduate route visa from this summer onwards, which will make things a bit more easier and a bit easier in terms of employing them. So we're about to move on to the changes to the student categories. So just if you'll indulge me again and let us know how many CASs, how many confirmations of acceptance for studies your school assigns every year. Options ranging from we don't have a student sponsor license to it's nothing to do with me, so I don't know, and then some numbers in between. If you could fill that in accordingly, that would be great. Maybe we have some answers. It's nothing to do with me, so I don't know is our most popular answer. Well, that's very honest of you. But some schools, so we've got what 22 of you attending this afternoon who are fairly high volume, well, say pretty high volume users of the sponsor management system, assigning more than 41 CASs every year. Okay, that's good to know. Thanks very much for indulging me there. So what's changing as far as these student rules are concerned? The old Tier 4 general category for students aged 16 plus was replaced and has been replaced by the student category or student route. You'll notice I'm using the word route. That's government terminology. Instead of talking about immigration categories or immigration schemes, the new terminology seems to be to talk about them in terms of routes. I don't know why. Somebody's obviously thought it polls better or something. I don't know. The Tier 4 child student has now become and transformed into the child student category or child student route. The headline, I think, really, as far as we're concerned, is that the child student category continues as effectively the independent school visa. You could call it the independent school visa because we are the only people who can use this particular immigration category is exclusively for students who are coming to the UK to study at independent schools. And for those of you who aren't familiar, you'll see that there's this overlap between the child student category and the general category. Sorry, the grown-up student category, if you will. Under student category, you can come from the age of 16 plus. Child students can come up to the day before their 18th birthday, or can apply for the visa on the day before their 18th birthday. So a plea as much as anything else for those of you who are working with students, and if you are a senior school with a sixth form, do please continue to try to use the child student category as much as you possibly can. Student really should only be used where you're absolutely desperate because the child, for whatever reason, is applying because they're over the age of 18. Much easier for us. I don't just mean us as advisors, I mean us as a sector. If we use the child student category, it's subject to a bit less scrutiny and is designed for use by independent schools. Quite a significant change is that visa applications can be submitted up to 6 months before the course starts. So it was always the case that the CAS could be assigned up to 6 months before the course starts, but then the student either had to hold on to it waiting until 3 months before, or more commonly, we would not give the students the CAS until 3 months before the course started, because we didn't want them to use it too early. So now we've got a longer window in which they can make their visa applications. We're getting up to the point when we'll probably start assigning CASs. So for those students who are starting in September, we can assign it in March, and you can give it to them straight away, and they've got then that 6-month period in which to make their application, and hopefully in every case granted their visas. No refusals this year, please. So that's a nice sort of useful practical change. Another change that those of you who are familiar with the workings of the category will be aware of, this idea of differential evidence countries. So certain countries which aren't required to submit evidence of their finances with their visa applications. They may well be asked to produce that evidence of finances, because they're not exempt from the financial requirement. They're just not required to submit the evidence of their finances. And there are certain sort of trusted countries, I suppose we would describe them as, which benefit from these provisions. And that list has been expanded, although only expanded to cover the EU countries. So while European students now will have to apply for visas where they're coming to the UK for study at our schools, and that obviously is, as far as they're concerned, not a good thing at all. I don't think it's a good thing from any of our perspective, is it? We don't want to be doing lots of additional admin for these students. So obviously it's not a good thing for the students, though, having to apply for these visas, but they don't have to submit evidence of their finances. But as I sort of said rather clumsily just a moment ago, that evidence does still need to be there, because it can be requested by the visa officer, and so it's important that the funds are in place, even though they don't have to submit evidence of those funds. One change in relation to finances, which is quite interesting, and which I wonder if might start to see a change in practice in some of our schools, is that evidence of finances doesn't need to be submitted for an in-country extension application. So if a student's been in the UK for 12 months or more, and is then applying for an extension of stay. So, for example, they're moving from GCSEs to A levels. If they make that application from within the UK, then they are exempt from the financial requirement. They don't need to submit any evidence of their finances, and they don't even need to declare that they have the finances. They are exempted from that requirement. It is assumed under the rules that they've been able to support themselves up until this point, so we assume that they're going to be able to continue supporting themselves afterwards. So the sort of question I have here is whether it might therefore be better for, particularly in those situations where students are transferring from year 11 to year 12 to the sixth form, whether it might be better to encourage those students to make the application from within the UK rather than making it from overseas while they're on their summer holidays with their families, because of that requirement of because they're exempt from that financial requirement, and the financial requirement is comfortably the main reason why we see student visas refused. The family either haven't got the funds at the right level, or they haven't maintained it in an account in the required format, and that's why, you know, boarding schools in particular would be asking wherever possible for the families to pay funds up front, because then they don't have to produce evidence of their finances either. So maybe just something to think about in terms of particularly with that transition from GCSE to A level. Something that's new in the student sponsor guidance, the guidance which used to be known as the Tier 4 sponsor guidance, is a new section on child safeguarding duties. And we've heard from the Home Office so far that they're not they don't see these as additional duties that compliant schools are now having to adopt in addition to those duties that they were complying with previously. They see this as just sort of articulating within the guidance some things that they were expecting to happen anyway. But I think it's still worth drawing these to your attention, just to make sure that you're aware that they're there for what, apart from anything else, but just sort of flag a couple of things about them that may not be may not be the practice at every school. So there's four points. The third one I've ignored because that just says that the facilities which are made available for child students comply with the relevant legislation. So the boarding house is compliant with the relevant fire safety legislation, for example, that sort of thing. Not really my domain to talk to you about that, and I would imagine that you're all compliant with that point anyway. First point, appropriate policies and procedures need to be in place to ensure the safety, well-being and protection from exploitation of the children which a child student sponsor is sponsoring. Again, I would expect you all to have decent, robust safeguarding policies in place already. The only thing I would flag here is just if it doesn't already, just maybe see whether there's a way of making reference to the international element that's associated with children you're sponsoring. So the fact that there may be agents involved, that there may not always be possible to communicate directly with parents, for example, because they don't speak English. Those sorts of things. Just making reference to that international dimension, I think within those policies would be good. Next point, living arrangements must meet the requirements of the route. What they mean by this is that there are some discrete categories within which sponsored students can live in the UK. Those we've already alluded to this when we were talking about private fostering arrangements. Just to sort of go through the approved arrangements very quickly. Boarding is obviously absolutely fine, and then for day students, they've got to fit into one of four categories. One is with a private foster carer, one is with a close relative who is settled in the UK, so a British citizen or has indefinite leave to remain here. Another approved arrangement is where they're either 16 or 17, in which case they are permitted to live independently. And the fourth approved arrangement is where they are living with a parent who holds a parent of a child student or parent of a Tier 4 child visa, as it was previously known. So those are the five categories in which sponsored child students can live in the UK. And what this sort of new provision within the sponsor guidance is saying, which we had understood to be the case, but was never really articulated anywhere previously, which is that if a student moves or their living arrangements change while they're in the UK, they need to still fit within one of those five categories. So a boarder can't just start living with a parent who is visiting the UK, or they shouldn't be. Similarly, they can't just live with a family friend because the parents can't afford your boarding fees anymore, and they want them to become a day pupil. That family friend would need to become a private foster carer in order to fit within the approved living arrangements. So again, just one to watch out for. It has a bit of a COVID dimension to it as well, because as I've already said, there will be lots of sponsored child students who are now day pupils when previously they were boarders. So yeah, do watch out for that. And then the last of these points is the one that I think we're perhaps the most concerned about, but so far have been reassured by the Home Office by their assertions that this isn't requiring anything over and above that which schools are already required to do, which is that all staff who come into contact with children have to have a current enhanced DBS, disclosure and barring service check. And the concern is there, what do the Home Office mean by current? At the moment, just from just under the relevant KCSIE requirements and safer recruitment requirements, it's only a requirement that you do the DBS check when someone starts work. We don't have to do it on an annual basis or a refresher. And of course, there will be members of staff who are grandfathered in because they were first employed before any of these requirements were put into law. So slight concern by the wording there. We are hoping the Home Office will clarify it, but as I say, what we've heard from them so far is that you just have to be complying with the usual requirements for getting DBS checks for members of staff. Before moving on to workers, I just want to talk about the visit rules because there are some changes here, and it is something that we have been getting quite a number of questions about, particularly within the European dimension and in the context of European students coming to study at schools for 1 or 2 terms rather than for a full academic year. So under the previous visitor rules, the pre-1st of December visitor rules, visitors can only study in the UK for a maximum of 30 days. If they wanted to study for a period of up to 6 months, they couldn't do so as a visitor. They had to be specifically granted entry or a visa as a short-term student. And then on 1st of December, the short-term student category was rehashed, reformulated, so that it only really applies to English language study for periods of up to 11 months. Now, anybody who's granted entry as a visitor can study for up to 6 months at an accredited institution. And if you are an independent school, if you hold a child student sponsor license, then you are an accredited institution as defined within the visit rules. So what this means is that potentially a visitor can come, someone who's coming just for 1 term, certainly would be able to do so for up to 6 months. Now, what we don't really have in the rules or indeed the visit guidance at the moment is any clarity about what they mean by studying for up to 6 months. I mean, potentially we could say, well, the student's coming for a term, that's less than 6 months, and then they're going to go home and they're going to come for another term, and that's less than 6 months. And then lo and behold, the 3rd term would also be less than 6 months. That would almost certainly be counter to what the Home Office are intending by this route. And I would even go so far as to say that although it's not within the rules, within the previous rules, the course itself couldn't be any longer than 6 months. And I would say that if someone's coming for a course that is of more than 6 months, so in the usual formulation, Michaelmas and Lent terms would be more than 6 months, point to point, start to end, if that's the arrangement. I would say that is probably not what is intended by these rules, and you run the risk of students being refused entry if they're coming to do that, even if they're going home for Christmas, even if the period which they'll be in the UK continuously for is less than 6 months, because the course itself is more than 6. I'm pretty uneasy about that, and I would counsel against it. But we are waiting for some more guidance on how these rules are supposed to be interpreted, and it may be that we'll see something a bit more liberal than my current views on this. But yeah, I would be cautious about any situation where a pupil is coming to study with you in total for more than 6 months, doing it anything other than as a child student visa route. Okay, I think I've probably waffled on a bit longer than I was intending about students, but that's okay, because it seems that most of you are here for the student chat anyway. So just to quickly go over some of the points around skilled workers. This is the category that replaces the old Tier 2 general category. It requires a skilled worker sponsor license. If you had a tier 2 general license, lo and behold, you now have a skilled worker license. Few headlines. The minimum skill level has been reduced from RQF level 6 to RQF level 3. We'll see in a moment what that means for us. The advertising exercise, the resident labour market test, has been scrapped. There was a cap nominally, that's now been removed. We have tradable points in relation to the salary requirement in this category. It's now much easier to switch immigration categories generally throughout the immigration rules, but that includes into the skilled worker category. So that's some good news, and we'll see a reduction in the UK's carbon footprint, sending Australian working holiday makers and youth mobility scheme visa holders having to travel back to Australia just to apply for their visa in order to come back and take a teaching job. They can now make those applications from within the UK. We've still got overseas criminal record check requirements for people coming to the UK to do teaching jobs, and there's still an English language requirement, as you might expect. What does a reduction in skill level mean? Well, probably not a great deal. I think generally speaking, the schools that we worked with on employee sponsorship issues were generally sponsoring teachers, so they qualified under tier 2 general. They continued to qualify under the skilled worker category. But look at some of the categories where we are now able to sponsor people where we couldn't previously. So nursery nurses. So if you've got a pre-prep maybe and you wanted to sponsor somebody to work there, then you can do so. Teaching assistants, house parents, chefs, if you wanted to get in an international chef for your kitchen, that's now much easier. But do watch out for these lower skilled jobs, because the point of conflict around skilled worker in the future will, I suspect, be around whether we're trying to sort of get people in under the RQF levels 3 and 4 occupations, when really they are better described as falling within a lower skilled occupation code. So just on the slide there, some examples of some categories which may affect people working in our schools. I've mentioned briefly, and I'm not going to go into a great deal of detail around the salary trade-offs under the skilled worker category. Teaching roles themselves are actually subject to their own thresholds based on the national teacher pay scales. Non-teaching jobs, headline salary requirement is 25,600, or the occupation rate for that particular job that you're sponsoring somebody to do, whichever is the higher of those two amounts. And then there are discounts available depending on the particular circumstances in which you're sponsoring somebody. So, for example, a new entrant, someone out of university, may qualify for a discount as far as their salary is required. But I think the thing to sort of maybe of more interest is just in relation to the salary thresholds for teaching roles. So these are the occupation codes which this covers. So secondary teachers, primary and nursery, and special educational needs. So not head teachers, they've got their own occupation code. They wouldn't be subject to these thresholds, but everything up to a deputy head, for example, on the teaching side, would fall within these, and these are the going rates. These are the minimum salaries to be paid for teachers. It will depend on where your school is. So we've got and this is all with reference to the, as I say, to the national teacher pay scale. So we've got separate rates for the different nations within the United Kingdom, Scotland, Wales, Northern Ireland, and then depending on how close to London you are, that will dictate the salary you need to be paying. Notice that some of the unqualified teacher rates fall below 20,480. Well, then you're going to have to bump them up to 20,480, because under the skilled worker category, you must always exceed, the pay must always exceed 20,480. And note as well that you could prorate. So a 0.8 or even a 0.6 teacher may well qualify, so long as the salary is above 20,480. and then the prorated amount it exceeds the going rate on the table there. Can be a bit confusing, but once you've got your head around it, it does make some sense. And if you've got any questions, then just let me know. And just to flag up that sponsorship under skilled worker was and continues to be a very expensive exercise. I won't go through the figures in detail, but in the hypothetical scenario where you've got a family of 4 applying for 5-year visas, then the visa fees or the various fees that have to be paid by the sponsor and the individual will total 17,839 if they're coming to work for a charitable school, or if it's a non-charitable school where you don't get a discount on that skills charge, the second bullet point, then it'll be £21,019, and that's not spread over the lifetime of the visa. That's all paid up front. That's all paid when you assign the certificate of sponsorship, and then when you make your visa application. So some pretty hefty layout there. Other relevant changes, well, I've already mentioned the graduate route and the fact that lots of categories really aren't changing at all, other than maybe a change in their name. And we may see the introduction of a unsponsored route for highly skilled workers. That's something which has been the government have been advised to do. I don't think they're terribly keen, so they might well kick that one into the long grass. But maybe towards the end of this year, maybe sometime next, we might see something around that. Quickly, just to mention, I did mention earlier the Hong Kong British National Overseas visa route. Just to flag, it does require a member of the family to hold a British National Overseas citizen passport, or to be a British National Overseas citizen. They don't actually have to hold the passport. Actually, they just need to have been granted that status. They also need to be resident either in Hong Kong or the United Kingdom. But then the category, unlike a lot of immigration categories, extends to the wider family members. So adult children with their spouse, for example, can come as well. But it will require, if there are children coming to your schools to study, then it will require the wider family to be moving as well. You couldn't have a child getting this visa on their own while the parents remain in Hong Kong. It will require the families to relocate with them, and you're competing with the state sector on this one. These children will be entitled to be educated at maintained schools and academies. So yeah, you're not suddenly going to get another 2 million plus kids, all of whom will be studying at independent schools. So just to finish up then on the situation for EEA nationals, we've got the EU settlement scheme, which is granting immigration status to those EU nationals, provided they were here before the 1st of January 2021. They've got this 6-month window until the 30th of June in which to make their applications under the settlement scheme. And as employers, you've got a grace period between 1st of January and 30th of June when you can continue to accept EU national passports and identity cards as proof of right to work in the UK. In fact, the government have gone so far as to say you mustn't discriminate during that period. So you can't insist on on an EU national holding status under the settlement scheme. But as I've said on the slide, do consider how you let new applicants, particularly from when they're from the EU, know that they may require some additional immigration permission. So either if they are entitled to apply under the settlement scheme, they should be looking to do that sooner rather than later. And if they're not entitled to that, you'll need to think about how they're going to get the immigration permission they need. So just something to watch out for. And there's a little sort of dance around the sort of discrimination issues there that government guidance hasn't really helped us on. From 1st of July onwards, though, it's going to be much more straightforward. When someone's starting work, irrespective of where they're from, you're going to need to see proof of their immigration permission, and a French passport or an Italian passport on its own won't be enough. They will need something else to prove that they've got the right to work in the UK. That could be status under the settlement scheme, or it could be something else. You don't need to be checking employees who have already started work for you. If you've done a compliant right to work check on them in the past, that will continue to protect you after the 1st of July. So we don't need to be going back and doing retrospective checks, but you will lose that protection if you know or have reasonable cause to believe that someone has lost the right to work in the UK. So if on the 1st or 2nd of July, someone comes into the HR office and says, I forgot to apply under the settlement scheme. It was in the back of my mind and I've forgotten. At that point, irrespective of whether you've done a compliant right to work check on them or not, you will probably have lost your reasonable excuse, your statutory excuse, because you will know that they probably no longer have the right to work in the UK. So we'll need to be a bit careful around those situations. And as I've already said, from 1st of July, everybody will need to prove their right to work through either a physical document or in the case of EU nationals, they're actually going to be getting, whether it's under the settlement scheme or otherwise, their status will be digital. It will be accessed via a government portal. So final poll, and then I think I don't have any slides after that, and then we've allowed a little bit of time, but perhaps not as much as I should for questions. So just final question, what steps have you taken to support or advise EEA national employees about their status? Here, you should be able to tick all that apply. So we don't have any EEA national employees. We've not done anything, we're leaving it up to them. We've written to everybody to advise them about the EU settlement scheme. We know who our EEA national employees are. We've sent out targeted communications. Some of you might be keeping a record of who has or hasn't applied. You might be doing something else, or it might not be anything to do with you and you don't know. So say if you could tick all that apply. Do we have some results? I'm not really saying you don't know. Targeted communications to EEA National, that's good. So you're confident that your HR systems tell you who's who, and so you've been able to target people specifically, that's good. And most of you have done something. You've written to everybody, you've kept a record. Not many are doing nothing. So that's good to see. All right. Well, I think I'm right in saying that is my last. It's not. I've got a slide on EEA student issues. I apologise. I've really eaten into my Q&A time. Just to say that the situation for students is a bit different. And you can have a look at the slides afterwards. But the only source of any compulsion to check immigration status on students is if you are a student sponsor. And as a student sponsor, you have a duty to ensure that students have the right to study in the UK. And under that duty, under that sponsor duty, I think we should be sort of thinking about whether we check that any students who will be studying with us after the 30th of June have applied. Probably a good idea to keep a record of that. And for students who aren't in the UK, you can't provide sort of advice on the application process, but you can certainly provide them with facilities to enable them to submit their applications if they don't have access to a device that allows them to carry out the identity verification steps of the application process. Right, sorry, I really have left very little time for questions. Maybe we'll skip this last poll, and if we move on to questions, Imi, and the planning for the future stuff, we can maybe well, we can leave our friends here to read when they get the slides afterwards.
Okay, fab. So we've had a lot of questions I'm conscious that we don't have that much time left, so I suggest we're probably going to run over a little bit and we'll get through as many as we can. If anybody does have to leave on the hour, then we are recording the session, so you can watch back any of the Q&A if you miss it. But let's not delay. I'm going to start from the top. We've got some questions in the Q&A and some questions in the chat box. I'm going to start with the Q&A box. And the first question we had was, we usually have a couple of foreign language students, assistants, Spanish and French, on a 10-month fixed-term contract from September to June. We do not pay them enough for them to be classed as skilled workers, so we cannot use this. How can we employ our language assistants going forwards?
I think it'll be difficult. They don't fit within skill. If they don't fit within skilled worker, I mean, there have been rumours for a long time that perhaps EU nationals will be added to the list of countries who can apply under the Youth Mobility Scheme. So if they're young and they're from the EU, then if that changes in the future, then they'll be able to benefit from that. But otherwise, there isn't an obvious immigration category for them, I'm afraid. They certainly couldn't come in for shorter periods just as visitors, because that would be classed as work. So yeah, if they're Spanish and French and they don't have any status under the settlement scheme, then yeah, I'm not sure there's any other immigration category for them.
All right, thanks, Tom. On to the next one. So what is the situation with non-EU visas, i.e. ancestry/youth mobility, if we are not being a sponsor for EU employees?
Oh yeah, so that I've just dealt with that with the last question, really. Yeah, we might see EU nationals being added to youth mobility, but not ancestry doesn't apply to EU nationals. It's Commonwealth citizens only.
Okay, great. So moving on, we have a child who travelled to China before Christmas and now can't get back as there are currently no flights. She's engaged in online learning alongside her peers and we have no concerns. We've made a note on her CAS. Do we need to do anything else? What happens if she is still overseas when the rest of the children return to school?
Well, she can continue to study remotely. So was there a bit in there about her visa expiring as well?
No, just that we've made a note on her CAS. Do we need to do anything else?
Yeah, no. Not really. Just to make the and to ensure that she continues to engage. That's the other thing. But yeah, it's perfectly fine for different approaches to be taken with different children. Some can be remote learning. Some can be in classroom. It doesn't. There's nothing that says that everyone has to be doing the same thing.
Great, thank you. Okay, next question. If a child applies for a replacement vignette as a result of coronavirus, will they be able to do so under the original CAS, or will that show as already having been used?
No, so the replacement vignette is a replacement for the visa that has expired. So while they will make reference to their previous application, it doesn't need a new CAS. It's just it's replacing a visa. It's similar to the situation where a student loses their BRP while they're overseas. They apply for a visa that just gets them into the UK, rather than it being they're not being sponsored again.
Okay.
Makes sense.
Yes, it does, I think. Thank you. Okay, next question. Regarding 1st of July right to work regime, are you expecting the requirements to be that an employer will have to check all of their staff, even those already employed, and have an immigration check on file?
No. So checks that you've done previously will continue to protect you. So you don't need to retrospectively go back and check people who you've already checked, and particularly where you've got a statutory excuse for those employees. So if you checked their Norwegian or Swedish passport before they started work for you, and you've kept a copy and it's on file and you can demonstrate all of that, then you've got your statutory excuse, and that will continue to protect you while you're employing them. So you don't need to go back and do any retrospective checks on those individuals from 1st of July or at any stage.
I'm sure people will be relieved to hear that. Okay, next question. Could a pupil come on a visitor visa for a term and then apply for an in-country child student visa?
No. Just expand that. You can't switch from the visitor category into child student. So they can come to study for a term on a sort of, I don't know, try before you buy basis, perhaps. But then if they want to stay on at the school longer term, they will have to go home, apply for the child student visa with the CAS, and then come back rather than being able to do that from within the UK.
Okay. And the next question I think might tie in with your answer there, but please can you confirm that a student arriving for just one term does not need a visa?
Um, if the course is less than 6 months, then I'm confident that comes within the visit rules. Some may still need a visa though. So if you are from a country where you would need a visa to come to the UK as a visitor, so pretty much all of Africa, most of Asia, so China, most Asian countries, you would require a visa just to come to the UK as a visitor. But if you've got that visit visa, or if you're from a country where you don't need a visa to come as a visitor, like the US or Australia, then you can be granted entry on that basis on arrival at the UK border.
Great, thank you. Okay, next question. Do you know if there will be any concessions introduced similar to agricultural workers for staff employed from abroad for summer schools?
I don't have any inside information on that at all. Maybe. I'd rather suspect not, just because at the moment the agricultural worker scheme is really specific. It's not even all agricultural workers, it's just fruit pickers or edible horticulture, as the Home Office term it. So whether that then gets expanded into other sectors, maybe, but I think we're probably quite a long way off from that happening, and it's only going to happen with concerted lobbying campaigns by particular interest groups, I would say.
Okay, thank you. Okay, we're going through these quite quickly, which is good. So on to the next one. For a school who does not have a sponsor license, does Brexit impact on the checks the school should undertake on their pupils or those applying to the school? I.e., do they need to check that they have the right to study in the UK or have settled status, etc.?
Yeah, no, that's a nice easy one, Amy. No, they don't, because the only source of any requirement to be checking the so-called right to study is from the sponsor guidance. So if you're not a sponsor, then there's nothing obliging you to check immigration status of any pupil.
Excellent stuff. Okay. For a student studying for one term only, what advice would you have for medical care that may be required during their stay, particularly children under age 13?
Right. That's sort of probably straying a little bit outside of my comfort zone, I would say. I mean, if they're here as a visitor, then they're not going to be entitled to any NHS care other than emergency treatment. So yeah, I think they're probably going to need to have some sort of private health insurance to cover other eventualities. If you're coming on a student visa, child student or student visa, then you pay the immigration health surcharge, of course, so you're entitled to full NHS care. But no, that's a good point, actually. So someone coming as a visitor probably would need something else.
Thank you. Okie dokie. I think the next couple we've probably already covered off, so I'm going to skip those ones. From 1st of July, do we have to check retrospectively that our EEA employees have EUSS, I'm not sure what that stands for, if they have started with us between January and July 21?
So even in that situation, you're not required to do any retrospective checks. The checks that you've done now, so that to comply now with the current right to work guidance, you can still accept an EU passport or even an EU national identity card. So if you've done that compliant check now, then you don't need to retrospectively check anything, which is somewhat counterintuitive, but that is the rule. So as the only scenario in which you may not have your statutory excuse would be if we know that they weren't entitled to apply under the settlement scheme. for one reason or another. Maybe they've told us that they arrived yesterday and don't have any entitlement.
Okay, lovely. Okay, next question. Even if someone has the immigration documentation, am I right in assuming that they are not a sponsor? If we are not a sponsor, we cannot recruit them?
No, that's not right. So immigration status is always something which is granted to the individual, but it may only be granted to the individual if there is a sponsor involved. So in the normal course of events, if somebody needs a work visa, and maybe so let's say that they're a teacher. If they don't have any other connections to the UK, they don't have a British partner, no British citizenship in their family line or anything like that, to work in the UK, they're almost certainly going to need a school with a sponsor license to sponsor their visa application. So the school gets the license, they sponsor the individual's visa application, and then they can come to the UK and work for them. But people can get immigration status that allows them to work without having a sponsor. So perhaps they're married to a British citizen and they've got a spouse visa that allows you to work. Maybe they're from a country which is on the Youth Mobility Scheme list, so they're under the age of 31. They're from Australia, for example. They can get a visa which is valid for 2 years. That allows them to work in the UK and work for your school. It's limited to 2 years, but there you go. But you don't need to be a sponsor to employ them in that situation. So you're not excluded from employing people who hold visas by not having a sponsor license, but you might find, and increasingly more so over the coming years, that you do need a sponsor license because you're not able to find the people with the skills that you need from within the much more limited labour market that we now have, which now consists of just the UK and Ireland and nothing beyond that.
Sorry, I was on mute then, but I was just saying yes, indeed. Okay, so we'll squeeze in a few more questions, and then I think we'll have to draw a line. So the next question, we have children who have been out of the UK since the beginning of December. Presuming that we are able to get them back by, say, the start of the summer term at the end of April, is there anything specific we need to be thinking of, mainly Chinese and EEA?
Not really from an immigration point of view, no. I mean, if they've still got their BRPs, if they've still got and still validity on those visas, then if you're complying with all of your usual record keeping duties while they're studying remotely, then no, there's not really anything. The only thing I might suggest is that you keep an eye on the current rules around travelling to the UK and whether they'll have to quarantine or get a negative COVID test before they travel, that sort of thing. But from the point of view of being allowed into the UK under UK immigration law, no, there shouldn't be any particular issues, not that I can think of anyway.
Great. Okay, next question. We understand that the Home Office can, at 7 days' notice, inspect schools for eligibility of pupils to be studying in English schools. Are birth certificates sufficient as a means to check nationality, or should we be asking for a copy of the child's passport prior to admission?
Well, so we did talk a little bit earlier about this sort of general duty that schools which hold a sponsor license are under to ensure that all pupils have got the right to study in the UK. And different schools will approach that in different ways. By way of a small plug, we actually offer a policy, a right to study policy, which talks about this particular duty and sort of talks you through the process and the requirements and helps you sort of focus on what sort of evidence you might accept. The difficulty when talking about right to study as opposed to right to work is that there is no prescribed list of things that you can accept in order to demonstrate that you've checked that someone's got the right to work in the UK. And there was some guidance which was published following conversations between the Independent Schools Council and the Home Office about 6 or 7 years ago, which sort of tried to clarify the position slightly, and the Home Office confirmed essentially that that if the school is reasonably satisfied that the individual has the right to study in the UK, if they're a British citizen, for example, and a birth certificate could be evidence of that, then they don't necessarily need to make any further inquiry. But one of the complications, for example, is that just because a child is born in the UK, that doesn't necessarily mean that they are a British citizen. So production of a birth certificate might actually necessitate you to make further inquiries to check that the parents are British or had settled status in the UK when the child was born. So I'm afraid it's not a sort of straightforward, this is fine, this isn't. But what we would suggest is that you have some sort of policy or a process in place so that you are able to satisfy yourselves and demonstrate to the Home Office that you're thinking about this duty and discharging it as best as you possibly can. A bit waffly, that one, sorry.
It's all right. Okay, I think we have time for one more. So I thought this was an interesting one. So we're currently recruiting and we're receiving lots of overseas applications. We don't currently have a sponsorship license. Do we need to get one? Is this compulsory? We've never had tier status.
I mean, I would say yes, but actually it's not compulsory. And if you are able to find suitable candidates who don't need immigration permission, who don't need to sponsor, well, that's going to be far less hassle than if you do start to go down the sponsorship route. Sponsorship under either the skilled worker or the student categories, as those who are involved would tell you, is pretty onerous. There are lots of record keeping and reporting duties. None of it in and of itself is particularly complicated, but it is just another level of burden, another level of bureaucracy that you've got to jump through. And so, if you think you can get away without getting one, then I would say, and I probably shouldn't be saying this because it's a large part of my practice, but if you can avoid getting a sponsorship license, then yeah, by all means do so. But I rather suspect that over time, with the reduction in the, as I've said already, the reduction in the size of our available labour market now and particular skills, more and more employers are probably going to have to start looking at it.
Fab. Okay, there's just one short question that I just noticed that you should be able to answer quickly. Should we have a separate right to work policy? If so, is that something you can provide?
In addition to our right to study policy, we also have a right to work policy. So yes, but so not a requirement to have one, but not a bad idea. So that HR staff who are carrying out those checks have got something to follow and refer back to if they've got any questions.